Now, again, these no action letters are guidance only. They're not regulations. The staff has retracted no action letters in the past when its opinion or when rules have changed. But for now, they are, in a way, some of the best guidance that has been put out there by the SEC with regard to what we should be considering securities, or really what sort of safe harbors we can be looking at to make sure that a particular asset does not meet the definition of a security. Now, in each of these no action letters, the participant or the requester that was coming forward to the SEC fell into the prong of a platform that had a particular intended use for a new blockchain asset that they were putting into use. So it wasn't a sort of broad distribution of assets on a chain while allowing others to develop that project. And it wasn't a platform that allowed for a lot of transfers of other blockchain assets to come in and out of that platform. So this was more in the line of a gaming platform, a platform for purchases of private airfare, and a platform that was intended to be a marketplace where people can purchase goods that will be delivered, but those purchases would be made in blockchain assets. And so the common features that the SEC found that would lead to not the asset in question not being a security is that the assets have some immediately usable purpose and can be used immediately on the intended platform. So in the instance of a gaming platform, you issue out tokens and participants can come to the gaming platform, play on the platform immediately after the issuance. There's no sort of development period. And with the second prong, the proceeds from the sale of those blockchain assets are not funding development of the platform. So there's no investment, essentially occurring where it's a paid upfront, value for the blockchain asset, and then the developer goes back and builds what's meant to be, part of the project. Essentially, what the SEC would like to see is that the project is already complete, and this, token that's been put out there is essentially just the currency that'll be used on the platform developed by that developer. The third sort of common feature would be that the asset is made continuously available for a fixed price. In this instance, I think the SEC is getting at the point that there's no expectation of profit when you can always get more of the same asset for the same price. So in each of the instances, I think at least in two, the expectation was each token that was being issued by the platform would be sold at $1. In the third one, I don't think they put a specific price, but it was intended that there would be some fixed price, and that each time a new participant came to the platform, they could always go back to the ATM, they could always go back to the token machine that's generating new tokens and continuously get a flow of tokens for that fixed price. So, if they did decide to, transfer it to anyone else or make any other transactions in that asset, there really would be no reason to purchase it for any more than $1 or whatever that fixed price is. So there really was no expectation that you would profit off of your purchase of that asset. And then finally, in all instances, the purpose of the asset had some consumptive purpose or some use on the platform where the user was coming in, purchasing the asset on the platform, and then immediately, or maybe after some time, using that asset on that platform. Whether it's redeeming the asset for, again, plane rides, redeeming the asset for gameplay, redeeming the asset for goods that are being sold on the platform. It essentially creates a currency for that platform, almost a gift card in a sense, where stored value is now being exchanged in for goods. And that seems to, all the promotional materials and all the descriptions that are provided by the developer sort of feed into this concept that, the platform is basically where that asset is intended to be used. And it's not really intended to be taken off the platform or used for speculative purposes. So again, although this is not legislation or formal regulation, the no action letters sort of provide a level of comfort to others in the marketplace that if you do follow these steps, you may be able to take comfort that the asset that you're engaging with is not a security. However, if you look at the steps that we provided, most of the projects that we see out in the marketplace, and most of the projects that are out there trading today probably do not fall within these categories. So it is a safe harbor per se, or at least guidance that would make one feel comfortable that the asset is not a security, but it is not generally guidance that is followed in each case of each project that we're seeing. Just to speak to the non-fungible tokens, I mentioned before that one of the criteria that we would look at from a perspective of U.S. federal securities laws is whether or not there's a common enterprise. The example being that with fungible tokens, the value of one token goes up because they're all essentially the same. The value of all tokens would go up, and therefore the SEC would view that as being a single enterprise where all boats sort of rise and fall with the tide. When it comes to non-fungible tokens, there's a stronger argument that there is no common enterprise, since each non-fungible token essentially acts on its own. You have a meme or a video of a particular basketball player in a particular setting in the NBA finals. That may be a more valuable token than an NFT of a picture of my shoes or something like that. Different tokens have different value depending upon the eye of the beholder, depending upon who's selling the token, who's in the token, what sort of desire or use that token has in the market. And because all of that is differentiated by each token, there's a stronger argument there that it fails the second prong of the Howey test with regard to being a common enterprise with other tokens of the same chain. So looking again at NFTs being blockchain assets, but having unique individual characteristics that would make them potentially fall outside of being a common enterprise with other assets. We have a few examples of recent enforcement actions that have taken place by the SEC's Division of Enforcement. In each of these cases, they were fungible tokens projects that were picked up. In each case, the SEC found that the token in question was a investment contract. Telegram and Kik have concluded. The Ripple case is not yet concluded. Therefore, is definitely a highly anticipated outcome there with regard to how the court in that case will be finding the Ripple token. But I think we'll leave it at that for now in order to get through the rest of the slides.
So many payment processors and cryptocurrency companies in the space, including cryptocurrency exchanges and transfer platforms, require federal registration with FinCEN and money transmitter licenses, or as they're commonly known, MTLs, in most states in order to legally operate. These companies, which provide money transmission services, are required to register with FinCEN as money services businesses. This registration process is relatively painless and requires the filing of a Form 107. A Form 107 provides general identifying information, including ownership structure, the states in which they plan to operate, banking information, and the location of supporting documents as they are to be kept in the US. Registration does not equate to licensure, but nonetheless still triggers anti-money laundering and know your customer identification requirements. For those interested, a publicly available list of all money services businesses registered with FinCEN can be found on the FinCEN website. Unlicensed money transmission, which has been held to apply to unlicensed cryptocurrency companies, is a federal crime. And notably, prosecution from unlicensed money transmission does not require a specific unlawful activity. Taking a step back, the federal definition of money transmitting includes transferring funds on behalf of the public by any and all means, including both transfers within the US or to parties abroad. A money transmitting business includes those that conduct currency exchange, money transmitting, or remittance services or those engaged as a business in the transmission of funds. A growing consensus across the United States has emerged indicating that cryptocurrency is to be understood to fall within the definition of funds. On a practical level, this means the business of transmitting currency falls within the wider definition of money transmission. We've prepared a number of slides to illustrate the ways in which a business may be providing such money transmission services, both in and outside of the cryptocurrency space. The first example is the classic fiat to fiat transaction, which is facilitated by a middleman operating the money transmission business. Here, party one uses the money transmitter to pass fiat currency to party two. The second example illustrates the crypto to crypto transaction facilitated by the money transmission business. Here, the business operates much the same as the prior example, except here, instead of the funds being represented in fiat currency, the funds are now exclusively in cryptocurrency. Nonetheless, these transactions constitute money transmission. In our third example, party one is using the money transmitter as an intermediary to pass fiat currency along to party two, who will receive the funds in the form of cryptocurrency. In this example, the money transmission business facilitates the transfer by converting and transferring the fiat funds from party one into cryptocurrency to be delivered to party two. The fourth example represents the typical cryptocurrency exchange, in which one user transacts with the money transmission business to convert fiat to cryptocurrency. Although the money transmission business never transfers the funds to the third party, the conversion of the fiat returned to the user as cryptocurrency results in a transfer of funds requiring registration and licensure. In any and all of the previously described transactions, if the user is a resident of a particular state, the money transmission business must be licensed or otherwise legally permitted to facilitate transactions in that state. With this in mind, the state money transmission licensing regimes become the key focus for all such businesses operating in the United States. The state regimes are key because even at the federal level, a failure to register for a state license still constitutes a federal felony. The key source of such prosecutions arise from the knowing operation of a money transmission business in a state for which the operator is required to but does not hold a valid license. Stated differently, when a party knowingly engages in money transmission in a state in which they should be licensed before they have been granted a license, they can open themselves up to prosecution. To ensure that no inadvertent violation is made, geolocational filters are often utilized by these companies to block would-be users from accessing their platforms in jurisdictions in which the money transmission business is not permitted to conduct their activities. If a consumer on one side of the transaction is a resident of a state in which the money transmission business is not allowed to operate, then the money transmission business can be found to be in violation of their licensing requirements. The complexity of the state-specific licensure programs are complicated by the fact that each state operates within its own unique regimes, has state-specific licensing application requirements, and requires different amounts or types of reporting by those licensed in their state to continue to conduct their operations. The state-specific regimes related to money transmitter licensing vary widely and do not all treat cryptocurrency in the same way. The key differences between states often arise as it relates to the state's statutory definitions for money or monetary value. The licensing process in even one state is a complex, time-consuming, and expensive process. To launch a nationwide licensing plan requires a depth of regulatory knowledge that has created an otherwise artificial barrier to entry for many would-be money transmission and cryptocurrency businesses. A nationwide rollout can cost all in anywhere from $1 to $2 million. These fees include legal assistance, surety bonds, background checks for key individuals, security audits, and other state-specific costs. Some costs, such as the surety bond and examination fees, are reoccurring and can vary based on the size of the money transmitter's business in the given state. We partner with trusted surety bond providers with expertise in the industry to provide our clients the highest level of refuge from these costs related to surety bonds. An effective nationwide rollout takes approximately a year and can be belabored further by heightened regulatory scrutiny. However, if mistakes are made during initial filings, regulators will often respond requesting updated information and even supplemental information. The extent of these requests can extend an application for months or even years. Although many of the state-specific requirements of licensure vary, some industry standard requirements have developed in the space. Notably, all licensed money transmitters are required to maintain a comprehensive written anti-money laundering policy, which addresses OFAC regulations and Bank Secrecy Act requirements. These policies must be independently reviewed and at least annually checked to ensure they comply with all of the responsible parties. Furthermore, anti-money laundering and Bank Secrecy Act training must be provided to all personnel upon their onboarding and at least annually. Once a company successfully completes their application and is licensed, they then face reoccurring post-licensure obligations. Once licensed, licensees must make annual and quarterly financial filings. Annual filings must be audited, and the audited financials can cost between $30,000 to $50,000. If an internal change occurs at the company, such as a change in ownership or a change in executive officers, state-specific notice requirements are required prior to these changes. At all times following licensure, state regulators may notify licensees that they have begun an examination into their business. If a licensee is notified that they are under examination, additional disclosures and communication with the regulator will be required. To this end, and in all facets of the licensing process, state statutes give wide deference to regulators to administer their roles as they see fit. The majority of state money transmission licenses are applied through and maintained via the National Multi-State Licensing System. The NMLS system is the official system for companies and individuals seeking to apply for, amend, renew, and surrender licenses. NMLS itself does not grant or deny licenses. However, the policies that govern NMLS can often be pivotal in the money transmission licensing process. The stated goals of NMLS is to employ the benefits of local, state-based financial services on a nationwide platform that provides for improved coordination and information sharing among regulators, increased efficiency for the industry, and enhanced consumer protection. For those states which participate in NMLS, licensees in those states are searchable on NMLS's website. Each licensee will have an NMLS ID number, which can be used to identify them on the website. Further streamlining the process is the system known as the Multi-State MSB Licensing Agreement Program, or the MMLA, which allows for an even more efficient licensing process among state regulators. There are 31 states currently participating in the MMLA program. MMLA works in two phases. First, the applicant is assigned one of the Phase 1 review states. The Phase 1 review state then has the responsibility of certifying to the other state agencies that the applicant has satisfied all of the general requirements. Once the applicant passes the Phase 1 review, each participating state agency will then perform their individual Phase 2 review. During the Phase 2 review, states will look to find their state-specific requirements. If the Phase 2 review is successful, a license will be approved and granted by the state agency. NMLS in general and the MMLA program in particular provide an efficient avenue of mass licensure. However, to execute a full nationwide rollout, companies must turn to some individual state application systems to achieve their licensure. For example, both Florida and New Jersey operate their licensing process through state-run online platforms. The policies, statutes, and systems of application are unique to these states. On state platforms, post-licensure obligations, such as financial reports, are still required. However, the submission process and forms required to make these submissions change. Alternatively, in Montana, no money transmission licensing regime exists, allowing cryptocurrency companies ease of access to the market. Pennsylvania does maintain a money transmission licensing regime. However, the Pennsylvania Department of Banking and Securities issued guidance in 2019, which relaxed state money transmitter licensing requirements for cryptocurrency companies. Effectively, this means most cryptocurrency transactions can be conducted in Montana and Pennsylvania immediately and without licensure. New York, however, finds itself on the far opposite side of the regulatory spectrum to the likes of Montana and Pennsylvania. Cryptocurrency companies cannot operate in New York until they receive both a money transmitter license and a BIT license, or are otherwise authorized by New York's Department of Financial Services to conduct virtual currency business in New York. New York's review regarding MTL and BIT license applications for cryptocurrency companies is notoriously rigorous. Having prior approval from other regulators and showing a history of compliant business practices will help support any New York application. A premature application in New York, however, could lead to a denial of a license, which would require a universal reporting to all other regulators. For these reasons, we instruct our cryptocurrency clients to wait until they have a sufficient track record before applying for an MTL or a BIT license in New York. Just as no two companies are the same, no two rollout strategies will be the same. Companies have the option to petition regulators for no action letters, which provide a formal request for approval to operate in a particular state based on an interpretation of the state's applicable statute. No action requests describe the company's proposed operations within the given jurisdiction and provide the regulator with a basis on which to determine whether the company requires an MTL to run their business in the given state. In some cases, regulators will provide a formal written response confirming the company's position. In other cases, a less formal email will be provided confirming that no license is required. If a company is granted no action in a particular jurisdiction, their activities will be legal so long as they operate within the parameters of the sanctioned activities outlined in the regulator's no action response. The scope of legal activity will be limited to the language of the no action response from the regulator. In other words, if the company's business offerings change, or if the state statute is amended, the company will no longer be able to rely on the regulator's previous no action letter. Another avenue of operation without licensure is known as reciprocal approval. Some state statutes provide a carve-out for those who have been licensed in a state with similar statutory regimes. If licensed in an applicable state, the company can petition the reciprocal jurisdiction to allow them to perform money transmission without a formal license application process. Finally, exemptions to licensure do exist. However, these exemptions vary widely from state to state and are often contingent upon the company's business model or formation structure. The best means of ensuring that an exemption applies is to contact the relevant regulator for a formal no action response. However, some states have notably refused to provide no action responses, and in these states, the company may operate based on their interpretation of the exemption, but do so at their own risk. To summarize, licensure provides the widest prophylactic defense against prosecution. However, licensure comes with high upfront costs, heightened scrutiny, and recurring obligations. No action early provides companies quicker access to particular jurisdictions, but is subject to denial and is limited in scope. Reciprocal approval is limited, with only a handful of states offering it. And exceptions, although useful, often leave the company open to countervailing statutory interpretations. I want to take this opportunity to thank you for your time and attentiveness. And please feel free to reach out if you have any questions. And I pass it to Alexandra.
Thanks, Ethan. I know we are actually starting to come up on time for Q&A, but I wanted to take a few minutes and give an update on recent developments. One of the things we've been trying to illustrate so far this morning is that there is a lot of regulatory uncertainty in the United States when starting a cryptocurrency project, both in terms of the classification of the blockchain token, the digital asset itself, and also on how the flow of funds or the transmission of the digital assets will be regulated. And one of the things we've been trying to discuss so far is there's a securities law regime governed by the SEC. There's a money transmitter licensing regime that is run both at the US federal level and individually in almost all 50 states. One thing we have not yet touched on is the commodities and derivatives regulation that's run through the CFTC, the Commodity Futures Trading Commission, which is another US federal regulator. The CFTC regulates digital assets in a couple of different ways. The first is that it has jurisdiction over regulating commodities. And starting in 2016, the CFTC started asserting that certain digital assets, most famously Bitcoin and Ethereum, were not securities, but were in fact commodities. And so the CFTC should have jurisdiction over those. The CFTC has also more recently asserted that it has jurisdiction over so-called stablecoins. There's been a lot in the press lately about stablecoins. We have a quick slide up that stablecoins, generally speaking, are cryptocurrencies with value pegged or tied to that of another currency, commodity, or financial instrument. Some of the most famous ones are currency that are tied to one unit of fiat currency, meaning non-cryptocurrency. So USDC, by way of example, is a digital asset where each cryptocurrency digital asset represents $1 US. These are known as payment stablecoins. There are others known as algorithmic stablecoins that, rather than having dollar-backed or other fiat currency backed at a 1-to-1 ratio, the price is designed to be pegged to a dollar, but only by way of either algorithmic trading or by a basket of other digital assets. The reason this is important is that the CFTC has asserted jurisdiction over stablecoins, either because they're commodities or because they're derivatives. And happy to get into this in the questions. I know that there's a lot. What we really wanted to highlight is, from a US perspective, there has been concern in the US market, in particular from participants in the blockchain space, that there's both too much regulation that overlaps and also an uncertainty of classification. And that makes blockchain market participants either less likely to engage in their project in the US, or concerned about how the project should be regulated and how they should build it. We frequently spend time with our clients, either meeting with the CFTC or the SEC, trying to get some sort of guidance on how a project will be regulated. And to that end, starting earlier this year, the White House issued an executive order designed to say, we want to add some more certainty into the digital asset market in the US. The goal is to develop at least some form of more universal regulation. On March 9th, President Joe Biden issued an executive order directing several federal agencies to coordinate their approach to clarifying cryptocurrency regulations. They laid out 6 US national key priorities: promote US competitiveness within the global cryptocurrency market, which alludes to this idea that certain projects are trying to avoid the US entirely because of this regulatory uncertainty. Protect consumers and investors, promote financial stability, combat illicit finance, which I believe we're going to talk about in some more detail in our next session, promote financial inclusion, and promote responsible innovation. They also, in particular, wanted exploration of a US central bank digital currency, which we know several other countries are developing right now, in particular China and the UK, and the US is trying to further that goal. But blockchain market participants are really hoping for legislation that's more easy to follow, that facilitates innovation, does not require all blockchain tokens to be securities, because as Dan mentioned earlier in our program, it's not only the classification of an individual digital asset as a security or the issuance and sale of tokens as securities, it also means that every transaction in a digital asset on the blockchain is a US securities transaction, which makes running and operating a platform very, very difficult. And so one other recent development we wanted to discuss briefly before we take questions is just today, 2 Senators Lummis and Gillibrand, announced a new bill, the Responsible Financial Innovation Act, which is pretty exciting in the US because these are two senators that have gotten a lot of input from the digital assets industry in order to try to construct a law that would be easier to follow and would facilitate blockchain projects in the US. And this is really just brand new this week, but the main concepts included in this bill are that digital tokens that are decentralized would be commodities and would be governed by the CFTC. The CFTC would be given new authority to regulate them, and that would mean that the CFTC would govern most digital assets. The bill would designate digital currency as either an ancillary asset or an intangible fungible asset. If it is an intangible fungible asset offered or sold in tandem with the purchase or a sale of a security, it would not itself be a security. The law would treat all digital assets as ancillary unless they are for fundraising or give dividends, equity, or other traditional securities rights. And what this would mean is that many more of the tokens and digital assets issued by blockchain projects would qualify for treatment as commodities rather than for treatment as securities, which would be a major change in regulation in the United States and would really facilitate a lot of these projects being able to move forward. They've stated publicly that they work with both the CFTC and the SEC on this plan. It does include regulation of stablecoins and virtual currency generally, and this is really going to be the current topic in the coming weeks on the U.S. regulatory landscape. And I know we're into the Q&A, so with that, I'm going to stop talking and happy to take questions.
Hi. Hi, everybody. Hi, everybody. Good afternoon. Thank you, Alexandra, Dan, and Ethan for that very insightful session. Personally, I learned a lot, and we have questions in the Q&A, but I thought to mention that any Nigerian-related questions that will be asked today will be addressed in subsequent sessions, which we hold tomorrow and Thursday. So for today, we'll be focusing on US-specific questions. So if you ask the Nigerian-specific question, please bear with us. We won't be taking that today. We have some very good questions here. First one is, Nat Dozier, and pardon if I didn't pronounce your name correctly, is asking that aside blockchain and other similar platforms, there are other fintech novelties such as mobile loan or credit apps that provide credit facilities to subscribers. So he wants to know what laws or regulatory structure can be used to control their excesses in the US. The question is directed to no one in particular.
You want me to jump in? That's a great question, and it's a very involved question. And I think if I understand correctly, it's about what US laws may apply to other fintech products such as decentralized payments or mobile banking systems. And that's a pretty involved question. But in addition to some of the money transmitter issues that Ethan discussed, some of those projects are regulated as traditional banking products. And so we would be looking at the US banking laws when we're assessing products like that.
Understood. I hope that answers the question posed. The next question here is, how does the United States SEC deal with regulating offshore entities that issue digital assets considered as securities with US citizens in targets?
So that's a great question. And, Dan, please jump in detail. But Dan, why don't you go ahead?
Yeah, I think this kind of gets to the theme of, a couple of things popping up in the chat of, well, how does this relate to Nigeria? How does this relate to offshore transactions? And why are we, presenting on this particular topic? It's because the way in which the SEC looks at a particular transaction, again, each transaction needs to comply with securities laws. They're going to look at who is issuing the security and who is receiving the security and where was that transaction negotiated. So in this instance, if you are selling cryptocurrencies or blockchain assets to individuals who are US persons, doesn't matter if you are located in an overseas jurisdiction, the SEC will take notice of those transactions and they will consider those transactions to be subject to their jurisdiction. With regard to transactions that are wholly overseas, so a non-US entity sells cryptocurrency to a non-US person in an overseas jurisdiction, the SEC won't have, won't be reviewing that as much. And on the flip side, if there are certain elements that involve US jurisdictions, but other elements that don't, specifically if the purchasers are outside of the United States, but maybe the project or maybe elements of the project are within the United States, the SEC does have sort of scaled exemptions with regard to when those securities would need to be, when those transactions would need to be registered with the SEC or when they would potentially be exempt from the SEC's review. So that's kind of the reason why I think, being aware of how the United States and the SEC regulate this space is that if you do have any transactions with US persons or persons within the United States, those transactions do fall within the purview of the SEC and would need to comply with the SEC requirements.
Thank you, Dan. I would like to say that in the interest of time, we'll be unable to address all the questions. So I'm sending my apologies in advance, but we will take as many questions as we can. I also note that some people are dropping questions in the chat box. Please, if you need us to attend to your questions, put them in the Q&A box. All right, and the next question is, with the dread of criminal activities posing as authentic crypto markets, how can one possibly know the real and licensed crypto companies to invest in?
So that's a difficult question. There are a number of different ways to answer that. I think it's getting to two things. One is there a way that we can research what kinds of licenses a crypto company has or that their digital assets has? And I think Ethan alluded to one of them, which is being able to look up whether a company has been licensed by FinCEN as a money transmitter. There are also state websites that allow the same thing. Unfortunately, even if people sell their digital assets as securities, if they were privately placed, it's hard to find that information publicly available. There are some crypto exchanges that provide more information about the digital assets that they list. The other thing to keep in mind, and we are going to talk about it in the next panel, is that there is opportunity for cybersecurity issues and potential fraud, and that's something to really have caution about. Even if a digital asset has been sold as a security or the company is licensed, because there can be third-party bad actors as well that one needs to be aware of.
Thank you. I will take one more question, and we have about 17 questions here. I know that, or if the Magdemon team do not mind, we could send all these questions to the team, and when you provide a response, then we'll circulate it to the participants. So if your question is not addressed now, we'll circulate it to the team, and when they revert, we'll share it. So the last question is, how is NFT valued in the NFT market? And can any claim pursue, or are there any claims, or are claims pursuable in the US court? Okay, sorry, let me read this again. How is an NFT valued in the NFT market? And can any claim pursued in court arise from NFT transactions?
Yes, I think value-wise, the market's going to determine what that value is. So, whatever others are willing to pay for the asset, that's going to be, how it'll be priced. I think, within the scope of what we're looking at, if it's treated as a security or not a security, there are certain claims that can only be brought when a security is involved. So if a security is sold and it's not registered or it's not sold pursuant to a valid exemption, there's an immediate rescission right that the purchaser is going to have with regard to that product. So if they have buyer's remorse afterwards and they want to get their money back, there's a specific claim that they could bring in U.S. courts with regard to getting that back, simply because it's a security and was not sold pursuant to the laws of the United States with regard to securities. Now, otherwise, if there's fraud involved, that there's other, elements of, laws being broken involved, then there'd be a number of other claims that could potentially be brought. But I think the sort of focus that a lot of projects will have in this space is because of that rescission right, because of the restrictions on selling securities and the need to do so in a compliant manner. There's a very big focus there on whether or not that asset to begin with is or is not a security.
Thanks very much for that, Dan. And thank you to Alexandra and Ethan and everyone else on the MWE team for that session. Again, everyone whose questions couldn't be taken, please keep them coming. We will log the questions together and share with the team subsequently, and then share the responses. But very quickly, so that we keep to time, we're going to roll into the next session. And this session, on that litigation note, is a session that focuses on crypto litigation and enforcement. And it looks at some of the current trends that we're looking at, that we're seeing now. And I'd like to also from the MWE team, Joseph Evans. Joseph, hi. Daley Epstein and Aaron Brogan. Gentlemen, please take it away. You have, as I said, 45 minutes for this session, and then hopefully reserve the last 15 minutes. Oh, hi, Daley. The last 15 minutes for questions and answers. So over to you.
Thank you. It's nice to be here, and we may well leave some additional time for some questions, because it seems like there were some very good questions that we don't have time to answer, but we may be able to help out, and so we'll try to move quickly. My name is Joe Evans. I'm a litigator by trade. I'm in the New York office here. We have a team that's entirely devoted to cryptocurrency work. It's all we do. I've been in the industry since 2013. Started out representing people that may have been using crypto for things that they shouldn't have, and then started defending investigations and bringing active litigation. And then the practice really moved into making sure that companies are being operated in the correct manner and pursuing litigation and stolen crypto where we can find it. A big portion of our practice now is tracing, finding, and obtaining crypto that has been stolen. And I'm joined here by my colleagues on my team, Aaron Brogan and Daley Epstein, who are also crypto exclusive. It's really the only thing we do. The practice has really been increasing substantially. And so we wanted to give a brief introduction called Crypto 101. And I just wanted to step back. I think that it's important for this group and for any group to know two basic things. What does any of this stuff mean, and why does it matter to me? And so in order to understand what we're really talking about here, we just want to go through some really basic definitions to explain what this is and why it matters. So we go through a few terms. One is cryptocurrency. What is it? There's a number of different names that you may have seen thrown around when you read news articles or writings. Cryptocurrency, digital assets, virtual currency, crypto. There are a lot of terms that essentially mean the same thing. And what cryptocurrency is it's a digital asset that exists on the blockchain, which is effectively on the internet. And with some exceptions, they're not backed by a government, except I know that Nigeria has a central bank digital currency, but most are not backed by a government. And they're effectively valuable because someone else is willing to pay for it. And the value is tied to whatever the demand is. And what crypto allows you to do that you can't do with other types of assets is I can transfer that crypto across the world without an intermediary. I don't need a bank. I don't need a bank account to do this. I can send cryptocurrency from where I'm sitting in New York to one of you in Nigeria, and all I need is your what's called a transaction address in order to do it. And so that's the real use case of cryptocurrency. Now, what we'll come to is that while it was initially created for the purpose of seamless transactions across the world without a bank, what it has effectively created was a series of middlemen that make it easier for me or you to transfer cryptocurrency from one place to another. So the most important crypto for everyone to know is Bitcoin. I think everyone's probably heard of Bitcoin by now. There is a total market cap of 628 billion as of today. It's widely regarded as the most popular cryptocurrency. It's trading at about 30,000 now. It was trading at about 61,000 before. And so Bitcoin has its own blockchain, meaning that Bitcoin is on the Bitcoin blockchain, is what it's called. And Bitcoin can be used to speculate, to invest, and hoping that it increase in value. It could also be used to buy things. And we're seeing an increasing number of purchases in Bitcoin and other types of cryptocurrencies. The next term that we need to describe is blockchain. What is it? Blockchain is underlying, it's a contract really, but it's the underlying code that makes this all work. And so blockchain is where the cryptocurrency is launched. It's where it's technically held. And the reason it's called blockchain is because when a transaction is submitted on the blockchain, it takes a few seconds, but all the transactions all over the world line up to be executed. And they're finally executed in a block. If you look at the top right-hand corner here, that's an image of a block, a sort of a cartoon image of a block. But they're all executed at one time. And when they're executed, when the next block is executed, they're tied in a chain. So all the transactions that are executed at the same time, those are the blocks, and they're all executed in a chain. And so we can go back and look online and see every transaction that was ever executed. You can't change it, they're there forever. And so that is why the blockchain is so unique. It's not a ledger that's held by a bank or a ledger that's held by a third party that can be altered. These transactions happened and you can never erase them. They're there, they exist. And we can go back and look at my first purchase of Bitcoin ever and whatever trades we did recently, but they're all available online all the time. And that's what the blockchain is. Now, there are a number of different blockchains. One is the Bitcoin blockchain, but two, and one that's very important, is the Ethereum blockchain. The Ethereum blockchain, it supports the token Ethereum, but the reason why it is so interesting and why it was so important for the industry is that it permitted market participants to make what are called ERC-20 compliant tokens. And what that means is you can very easily create your own token using the Ether blockchain. And so when you go online and you see a whole bunch of different tokens and crazy tokens with pictures of dogs and hats and whatever, those are primarily ERC-20 tokens. It enabled the market to get to launch their own token without having to build their own blockchain. Stablecoins, I know we discussed in our last meeting, but those are coins that are generally tethered to the US dollar. There are two types. There's a stablecoin that's actually tethered to the US dollar, or another form of currency, meaning that there is cash in the bank to support that token. And there are other types which have had some problems recently called algorithmic stablecoins, where there's some kind of formula that is supposed to keep them stable at a price of fiat currency. The use of stablecoins is most frequent in transactions for actual goods and services, including international transactions for actual goods and services. NFTs, Dan covered. The transaction hashes are a series of numbers and letters that identify a particular transaction at a point in time. And if you go to a website, you type in that transaction hash, you can see the wallet that traded the token and the wallet that received the token. A digital address is like your email address, your account number, what someone needs in order to send you crypto. And a digital wallet is where your crypto is held. Now, crypto exchange are important players here, because that is where the majority of people go to trade, transact, and buy and sell crypto. They're effectively a user-friendly place to execute transactions. Now, let's go to maybe the most important point for you all is, why do you care? Why does it matter to Nigerian lawyers what's happening in the US with crypto? And there's a couple of reasons why. One is there are significant US-based companies that are doing a lot of business in Nigeria, including some companies we represent that execute P2P platforms where they facilitate transactions between users in the US and elsewhere, end users in Nigeria and many other places across the world, focusing primarily on the unbanked community. And so where there's a lot of volume, there's a lot of transactions, there's central market makers and central intermediaries, there's going to be litigation and disputes on these issues. The other thing I would say is we've seen an uptick in international transactions in Africa and elsewhere that are being conducted in crypto. And we've seen disputes arise between a number of US people and a number of foreign people. And there are many foreign market participants that find themselves in US courts. And the other thing I would point to is the fact that we've done a ton of US-based litigation. We've done many of the first of their kind types of litigation. We haven't had a single one that hasn't had an international aspect. Because crypto is so easily to transfer worldwide, there is always an international aspect, and we use our colleagues from our offices all over the world, including the UK and Singapore and elsewhere. But there will be, each one of these crypto cases in the US always has foreign market participants in some capacity. And so I'm going to turn this over to my colleague to talk a little bit more about some of the litigation that's happening now in the US.
Hey all, I'm Aaron Brogan. I'm going to just share my screen here and see if I can get this. So Joe, right now, can you just see this the slideshow?
Yes.
Yeah. Okay. So yeah, I'm Aaron Brogan. I work with Joe and Daly and Alexander and Ethan and the whole McDermott team on cryptocurrency issues. I am a litigator by training. Most of my litigation has been in the United States, sort of as a facet of being a lawyer here in New York. Before coming to New York, I represented large companies, or before coming to McDermott, I represented large companies like ExxonMobil, Johnson & Johnson, and trials. And I moved into crypto in 2021 because I was interested in the opportunities that this industry provided. So I hope that this presentation can be illuminating to some of you if you are not already interested in the industry. So like I said, my litigation has primarily focused on the United States, and this presentation includes law that is primarily United States law. But I think it's relevant no matter where you are in the world to consider these issues, because many of the litigation issues and problems that I'm going to discuss are issues that'll come up in any forum, like finding individuals, how will you sue a decentralized organization that doesn't have a corporate structure? Those are issues that are going to come up everywhere. And secondly, because the US courts are a forum which many of these issues will be litigated regardless of where they are. And part of what this is going to go into is how legal issues that arise, not necessarily in the US forum, can be litigated in US courts, and how US laws might apply anyway. So I would start by talking about the issue of identifying litigants. So you are a plaintiff and you are harmed by, say, a decentralized autonomous organization. So this DAO concept is very important in the crypto space. And it's basically an on-chain organization. It creates some form of governance on the blockchain, which individuals, whether they be identified publicly or pseudonymous, can come together to do anything. So one of the central facets of a DAO is the treasury and a voting mechanism. So some notable DAOs, they can do very different things. One is Pleaser DAO, which you can see here in this slide. Pleaser DAO is a collection of artists, and they came together and raised money to advance the cause of art. They notably bought the Wu-Tang Clan album, Once Upon a Time in Shaolin, that famously Martin Shkreli had purchased originally. It's like a one-of-a-kind of album. They bought it back from the US. Another DAO that's important is MakerDAO. They create DAI, which is stablecoin that is essential to the architecture of crypto in a lot of places. So DAOs really can do very different things. And sometimes they should be liable to suit. So a lot of DAOs have no legal entity, which creates an issue in bringing suit against them. So traditionally in the United States, if you want to sue an entity, if you interact with them, if they're a counterparty in a contract, they would have some primary place of business, they would have citizenship in some state, and then that would be a forum which you could sue them. Because DAOs don't, or often don't, have that kind of corporate entity, it's a little bit harder to figure out where that would be. So that seems like an issue, but it may actually be a benefit in certain litigation contexts. Because when there is no corporate structure, when an organization doesn't avail itself of the protections of an LLC or of a C Corp or of whatever corporate structure in whatever country, a lot of law and common law in the United States will generally treat that as a general partnership. So a general partnership is like the most basic form of corporate entity. It exists when there's no action to form something specific, but people come together to operate as a single unit. And the beauty of a general partnership, for litigation purposes, is that all of the members can be jointly and severally liable. So if you go down to this, you can see all the members, which could be the founders, or it could be potentially even beyond that, anyone who invests in the DAO will be jointly and severally liable, which means that if you sue one of them, you can bring an action for the entire damages of your entire claim. So everyone is liable for the whole. They all can indemnify each other, but they're liable to you, the litigant, for the whole of the damage. So because there's no corporate protection, and because DAOs don't provide this, people in crypto often rely on sort of pseudonymous names. They don't reveal who they are before they don't reveal who they are publicly. And this is an attempt to protect themselves from litigation. But it's likely that in litigation for major issues that those members can be identified. So one option that U.S. litigants have is you can file something called a John Doe lawsuit, which is a lawsuit that names a John Doe, somebody who is unknown at the time. And then you say, I had some injury, somebody did something to me. This is why I have a complaint. And then you may be entitled to, in certain circumstances, something called jurisdictional discovery, which allows you to focus on somebody who has interacted with this anonymous individual or this anonymous DAO that has allegedly harmed you, and gain information to figure out who the person is or who members of the DAO are in real life. So this approach of filing John Doe litigation is a good opportunity for litigants to identify pseudonymous principals who may be behind these DAOs. So if you take those two concepts, the ability to identify them with John Doe litigation and the joint and several liability that comes with general partnerships when there's no corporate protection, I think there are a lot of opportunities to bring suit against DAOs. So say you bring a suit, now there's the issue of, can you apply US laws? And this is an important question because US securities law creates a private right of action for unregistered sale of tokens. So say a DAO wants to release a token, Bitcoin is maybe a token, Ethereum is a token. There are a number of ERC20 tokens, which Joe described in his presentation. So a DAO wants to release a token that is potentially subject to US securities law, but there's this body of case law that may shield some tokens from US law. And so this Cavello Bay case has been important in the space over the last year. And basically what this says is if the issuer of the token is non-US based and the purchaser is non-US based, then there may, and even if there are some incidental contacts, like even if the sale existed in the United States, US securities law may nonetheless can't be applied. And really there's no jurisdiction for US securities law. And so this is an important consideration, not just from the litigation side, but also in some cases when you're advising a company, how they're going to set up, where they're going to set up, and how they're going to make a token offering, that there's a way to get around this US securities law. So as a litigator, it can be a challenge. As a corporate attorney or a regulatory attorney advising clients, it's potentially an opportunity. So now you've brought your claim and you found the person to sue. You're in your forum. There's then the question of how can you recover value? And this is a particular issue in the cryptocurrency space because, as you probably know, cryptocurrency assets have been very volatile throughout their entire history. So at some point they could be way up, at some point they could be way down. If somebody harms you by preventing you from getting tokens that you're entitled to, you could miss out on time value of those tokens because you could have sold when they were really valuable and you didn't because you didn't have them. So now, okay, you file litigation, can you just recover those tokens? If the tokens have gone down in value, you as a litigant may not want that. So this idea of intermediate value, which you can see on this slide, is an important one that has also recently gained foothold in United States law. So there's a historical concept, case line from the 19th century and from British case law of intermediate value for securities, which basically says if you have a stock that you were entitled to and you didn't get it, what you're entitled to as damages in a case for recovery in that action is the highest intermediate value from some reasonable time. And so this had been a theory in crypto for a long time. In this case that you can see in this slide, Diamond Fortress, which recently was decided in Delaware, was the first to apply that to cryptocurrencies. And we think that's going to be really important to these recovery actions because it's going to give the opportunity for litigants who were entitled to cryptocurrency at some point in the past to bring litigation and recover the value of that cryptocurrency when it was really high. So like if you look at tokens like Solana or AVAX that were really high last year and now this year have gone down, something analogous to that, you could recover that value that has since gone down. So the final thing that I wanted to touch on in this presentation is the issue of sophistication of key stakeholders. And this is something that we think a lot about in our cryptocurrency litigation, and it goes, in multiple directions. So on one hand, a lot of the executives, a lot of stakeholders in this space are younger and less experienced in litigation than traditional litigants. I mean, like the entities that I used to represent, the large Fortune 500 companies, had extensive general counsel offices. And I'm sure that some of you work with offices that are similar to this, where executives have been working with lawyers for years and years. That's often not the case in crypto. A lot of these executives made money young, they had a good idea, and they capitalized on it, and they took an opportunity in the market. And so they're around, 29, 30, 31, and they've never been in major litigation before. So we think about that as something that is not necessarily an issue, but it's something that we want to deal with when we're thinking about these cases. And we have to take into account that, these people haven't been in depositions before. These people haven't been in court before. And maybe it's appropriate to do a little bit more preparation and account for that fact. On the other side of the coin, judges are often less comfortable with cryptocurrency. And I suspect that is true everywhere. I mean, this is a novel area and not everyone has the experience with it yet. It has only in the last couple of years really breached the mainstream. So maybe your judge has heard of it, but doesn't know what it is or doesn't know how it works. And one way to deal with that is similar to what Joe did at the beginning of this presentation. giving a crypto 101 if this issue comes up in litigation. Teaching the people who are going to be relevant to the decision what the basic concepts are so they understand what's going on. And really, when you break it down, and it's a 10-minute presentation like Joe gave, it's not that complicated. People can understand it. And the second thing that we try to emphasize when we're dealing with this is that even if there are cryptocurrencies involved in these litigations, and even if that seems like a novel or scary concept, I don't know if you want to tell your judge that it's scary, but a novel or scary concept, the legal issues are the same as these judges are used to dealing with. And the factual issues are analogous to securities actions, to breach of contract actions, to fraud actions that these judges have been dealing with their whole career. And I think that emphasizing that in your litigation will be really beneficial as crypto issues come up. And that was the end of my presentation, and I'll pass it off to my colleague, Daley Epstein.
Hi, everyone. Can you, let's see. Okay, it's not showing me the screen that I'm sharing. So can you guys see my screen?
We can see it, Dylan.
You can see the slides. Okay. So hi, everyone. First of all, thank you all for being here. We're really honored to be presenting to you today. My name is Daley Epstein, and I work with everyone you've heard from so far today. But in particular, I work very closely with Joe and Aaron. Like Joe and Aaron, my practice these days is exclusively cryptocurrency regulation and enforcement. And in particular, so my background originally, I started my practice in Texas and was kind of doing broader general commercial litigation. And I have recently, my practice prior to joining this firm was partially crypto, and it's just been an area of interest for a long time. So it's been great to really kind of shift into working full time in this space. So the first slide that we are going to look at is this one. And I'm kicking things off with a meme. And the reason I'm doing that is because I think one thing when you're dealing with so many complicated concepts like what we're dealing with in crypto, it's always really good to kind of keep a sense of levity to it, right? And another thing that I found is really a hallmark of working in this space is even though the litigation and regulation, it can be very challenging at times, it can be very uncertain, there are both civil and criminal litigation, it's generally extremely entertaining. So this to me kind of sums up so that's part one. And the second reason why I kind of threw this meme on the first slide is that when you're looking at all of the different regulatory agencies, as some of my colleagues spoke about earlier, the question often is who's in charge? And the reason for that is because, as you can see by all of the different acronyms listed on the slide, there are a number of different regulatory agencies who operate in this space, and all of them have the same goal. And that goal is consumer protection. Because, as we've talked about, this is such an incredibly challenging and technologically specific space to work in, everyone's trying to figure out kind of how to protect the consumer. So the goal is that your client does not fall prey to looking like that meme. So the slide says the ABCs of regulatory enforcement. What do I mean by that? What I mean is that there are so many different players, and we'll walk through a couple of them individually, but one is the SEC, the Securities and Exchange Commission, another is the CFTC, the Commodities and Futures Trading Commission, and next is the IRS, they regulate our taxes, the DOJ, the Department of Justice. Each of those that I've named so far is a federal regulatory agency, but on the other side, you also have state regulatory agencies. And I'll flag briefly that state regulatory agencies are particularly interesting because their actions are often a lot less public. So if you Google enforcement actions relating to crypto in the United States, you often hear about these different federal agencies and some of the larger lawsuits, but there's a lot that happens behind the scenes with the state authorities as well. Okay, so the implications. What are the implications of having all these different regulatory agencies? So I think as Nigerian lawyers, if your clients are looking to operate in the US, I think the big thing that you need to make sure of is you're kind of checking the boxes in terms of understanding your potential liability with each of these different regulatory agencies. Because the way I like to think of it is a round peg in a square hole. All of the financial services regulations and the way they were drafted in the United States, the language isn't designed to fit cryptocurrency. And that's where a lot of these problems arise. Because the language doesn't match up so cleanly, you need to there's a question of jurisdiction regularly. And so it's whether something is a security, as you heard about in an earlier presentation, that may be unclear. And if it's unclear, it's not sure which agency is regulating. So I think one of the things that you really need to make sure of is that as these regulations continue to develop, they are slowly but surely becoming more applicable to the actual framework. Everyone's kind of redesigning the law, but you need to make sure that you're really understanding your client's potential liability in each space. So it's important to understand the context and the regulatory uncertainty, because both as an investor and as a builder in the space, it can be really hard to operate when the regulations are unclear, unsettled, and constantly changing. So a few things that to think about, though, is even though the regulations aren't clear, attorneys often make the mistake of thinking that regulators, they're not going to understand this technology. That's often not true. So while the government often has a smaller team that's choosing to prosecute these actions, one thing to be aware of is the actions that they do choose to enforce are often ones that they have taken the time to understand. So while if two parties are in business together and they get into a dispute, and it's for a large amount of money, it's often clear that they might sue each other. For regulators, it's not the same. So in order to get to a regulatory enforcement action, there's this concept called selective enforcement. And what that means is that they can choose which actions they choose to go after or not. So the actions that these regulatory agencies are choosing to go after are typically ones that they feel good about, they feel confident about their causes of actions, and they're usually fairly prepared to prosecute all the way through. So we're going to there's a lot to cover in this space because there are so many regulators, but we're going to walk through briefly a few of the main agencies who are players you should know and things you should be aware of with respect to each of these. So the SEC is the Securities and Exchange Commission. One thing to pay attention of is they often provide warnings or sometimes provide warnings. So the SEC in particular has taken a regulation by enforcement action in that they have not released clear-cut laws that say what you can and can't do when operating in the crypto space. And you've already heard a little bit about this earlier, but that is most particularly important when it comes to the issue of whether something is a security. And right now, the SEC has gone as far to say that Bitcoin and Ethereum, which are the two largest cryptocurrencies by market cap, the SEC has gone so far as to say that these two are not securities. And the reason that they made that distinction is because they decided that these two cryptocurrencies were sufficiently decentralized. And this has been touched upon a little bit in earlier presentations, but what that means is that there isn't a central party that's making the decisions and creating value for the token. However, aside from those two, a lot of the other larger market players have been subject to actions by the SEC. And I think this is an area that we're likely to see a lot of development in the next couple months in particular. So one thing that the SEC did recently is they recently hired a number of people to specifically work in their cryptocurrency group. And in particular, they're going to be prosecuting a lot more actions. And so that group is up to 50. So in the interest of time, I'm going to just kind of briefly touch on a few of the other regulatory agencies and what you should know. So there's also the CFTC. They regulate commodities futures, and they've determined that virtual currencies and digital tokens are likely commodities in certain respects. I think that's, again, one thing when working in crypto is that there are a lot of buzzwords going around. So it's really important to understand what it is that your client actually does and ask questions. If your client tells you that I have a digital token, that can mean a number of things, and understanding kind of how that token works, what its purposes are for the various analyses, that is incredibly important, because each of these regulators, when they do choose to enforce, all of these enforcement actions are incredibly fact specific. So that is something that I would definitely be sure to make sure you don't overlook or undervalue. Another agency is the IRS, and we mentioned that they cover tax issues, and virtual currency has been determined to be treated as property for US federal tax purposes, which is important. And again, one thing, as I mentioned, state authorities are kind of the player you don't really see, who has a very strong presence at the end of the day. And I think, and the other thing is, in the United States, we have 50 different states, and each one operates so very differently. And you have to get, in order to operate in each one of those states, you have to get approval from each one individually. So in addition to thinking about what your clients may need to do and where they may be subject to liability in certain kind of federal broader arenas, really, if you're looking to operate in certain states, you need to look at everyone. So we also have the Department of Justice, and these are a few of the main cases that have occurred in that space. And I'm going to close and pass things back to Joe in a minute, but I just want to kind of land on a couple of key takeaways. So the first is the importance of jurisdiction. So when operating in the US, and when thinking about operating in the US, it's important to note that what I was saying before, all 50, it's often, a key factor is often where the person's located. So right now I'm located in New York, and that subjects me to very different laws than if I were located in Texas. And so you need to understand kind of the liability and potential litigation risks in operating in those. But another interesting thing is, so because this can be so complicated, a lot of foreign companies often choose just to opt out entirely from operating in the United States. But at the end of the day, people who want to participate in this market are very determined, and a lot of this happens over the internet, and they're going to figure out how to do it. And of course, they do. So an interesting thing that they do is that they're often using geofencing and IP blocking, using VPNs to pretend to be in jurisdictions outside the United States. So key takeaways here are: do your homework before operating in the US. It sounds a lot scarier than it is, and it can be streamlined, but there are a number of things you need to pay attention to. And also, although the final takeaway is that although this regulatory landscape hasn't been particularly unified, we are pretty optimistic that in the next few months, things are going to continue to shape up. There's some litigation, there are some proposed laws that are going forward, and our regulators and government officials have kind of shown a very committed interest in understanding it. So we think that it will, A, change a lot in the near future, and B, hopefully become a lot easier for foreign participants to be involved in business operations in crypto in the US. So with that, I'll hand things back to Joe.
Thanks, Daly. Just give me 1 second. We've provided some written answers in the Q&A, so some of the questions have been answered already. I'm going to talk briefly here about crypto tracing and what it is. The reason why crypto tracing is so important is because there have been countless stories of people that get their assets stolen, that their Bitcoin is robbed, their NFT is taken, their Ether disappears, and what do you do? There's a unique, 1 second, unique to the crypto industry is that all these transactions are public. And so every transaction that's ever occurred on the blockchain is there for all to see. Now, you're not going to know at first who owns the digital address in which the stolen crypto was transferred to, but there's a pretty good way to find out. And the purpose of crypto tracing is to trace those transactions to ultimately identify who the bad actor is. We have a number of cases in which we hire crypto tracing experts. We use them on almost every single one of our cases. We train federal law enforcement agencies on crypto tracing. It is really the core of our practice when we're dealing with stolen assets. And also when we're trying to enforce judgments, when we have a commercial transaction that went awry, when we're trying to find out who these people are, where the crypto is, crypto tracing is the way to do it. And so the whole purpose is taking the crypto transactions, which I'm saying they're all public, but it's really just a lot of numbers. There's a lot of numbers. They kind of look like account numbers. They're called digital addresses. But how do we take those numbers and take these transactions and turn it into an actual person? How do we find out who's responsible? And so what we do is we use crypto tracing. And it's a lot different than fiat tracing cash. And for that, because the difference is with crypto tracing, all of the data is publicly available to us immediately. If you're tracing cash, we have to go to bank account and subpoena to subpoena. And we're often dealing with historical data. And so in the US and elsewhere, when you subpoena banks, you don't get it right away. You get it much later. With tracing crypto transactions, you can watch it live. So if a transaction happened right now, we could go on either Etherscan or blockchain.com and we could see that transaction. There is a concept that everyone thinks that crypto wallets and crypto trading is purely anonymous. That's not really correct. It's pseudo-anonymous. And what that means is that is a series of letters and numbers that identify a digital address. And that address is ultimately controlled by a person or an entity. And there's a way to identify that. It's not completely anonymous. And the tool that you use are these blockchain explorers. These are the URLs. I will put it in the chat box, but if you go to these websites, you can look at every transaction that's happening right now and every transaction that's ever happened. Now, how do we do this? What are you looking for? Now, when you have a crypto tracer, what you're looking to do is to attribute a digital wallet, that's where assets are stored, to a crypto exchange. And why are you looking to do that? You're looking to do that because most cryptocurrency exchanges are licensed, meaning they hold a money transmitter license like Ethan was talking about earlier, or a money service business registration, or a similar license from the UK, or a similar license from Hong Kong. And the reason why this is important is because those licenses require record keeping and KYC information, know your customer information. And so when you can trace a transaction to a particular wallet that you know is hosted by an exchange, you know that exchange knows whose wallet that is. And so how do you know that it's hosted by a particular exchange? And so what crypto tracers do is that they constantly do research and they use it from other investigations, but they have a huge database of digital wallet addresses that are attributed to a particular exchange. So they know that when this transaction hits this wallet address, oh, that's at Binance. This one's at Coinbase, this one's at Huobi. And so when you do that, you now have your target for your subpoena or your information request to say, okay, Coinbase, Huobi, Binance, whoever you are, I have this transaction, this is stolen, these are stolen assets that are at your exchange, please give me the KYC information for this particular individual, for this particular transaction. I'm going to move quickly because I know there's some questions that want to be answered. There is in the US, if you hit a US exchange, this information must be stored for 5 years. These entities are legally required to do it. And so if you send a formal subpoena request to a registered money service business and they don't have this information, they're violating the Bank Secrecy Act. And so what we always do when we issue subpoenas, when we issue letters, is we cite these provisions in the CFR. We cite these provisions in the Bank Secrecy Act that says, hey, this transaction is over $3,000. And if this transaction is worth over $3,000 US, all of this information you have to have. And in fact, you don't just have to have it, you're legally required to be able to produce it in a timely fashion. And so we always put the exchanges on notice that, look, this is our request, you're required to keep it, hand over the information. What we often do is both with US and international exchanges is that we'll ask for informal requests for information. We'll send an email, we'll send a letter, we'll say, hey, can you please give us this information because we know this is a stolen asset. And we've had success in getting this information from foreign exchanges, from US exchanges, where they say, well, we're not agreeing to jurisdiction, we're not agreeing that you have the right to serve us, we're not agreeing that you have the right to this information, but here you go. And that has led to some of our best findings in recovering stolen assets and identifying the actual people that are behind these digital addresses. Now, there's an issue with the cryptocurrency exchanges, and this gets a little heady and complicated, so I'll be quick. Most cryptocurrency exchanges have what are called a hot wallet. A hot wallet is effectively an omnibus account. And what that means is when new customers put money into that exchange, it gets commingled with a bunch of other customers' money. Now, the fact that it's commingled, that it's an omnibus account, that is what tips us off and the crypto traces off to know that that is a cryptocurrency exchange account. So that way we know, oh, that's the Binance commingled account. That's the Gemini commingled account. But it makes it nearly impossible to trace through. So once it hits that account, your tracing is effectively done. Now you have a repository of information, which is a crypto exchange, but it's very difficult to trace it after the fact. How do people evade detection? There are things called tumblers. Tumblers are just a money laundering operation. And what you do is, if you wanted to hide your crypto transaction, you send your Bitcoin to this particular wallet. It gets mixed up with a whole bunch of other people that are putting their Bitcoin in that wallet. And then when you want it back, you make a request for a different address and it spits it out. We've only once, maybe twice, been able to trace through a crypto tumbler, but it becomes very difficult. The other way that you can avoid detection if you're looking to be hidden is to avoid crypto exchanges. And so if you have a very sophisticated criminal that's stolen your asset and they never hit one of those hot wallets at a major cryptocurrency exchange, it is very difficult to trace. And because that's very difficult to trace, they can effectively remain anonymous. So that still remains a risk. Crypto tracing doesn't alleviate that risk. Now, what we've noticed is sometimes that particular wallet is very careful with the stolen asset, but is not so careful with other assets that are held in that wallet. And so you might find a very small transaction going to an exchange for a minor payment or a minor transaction, and that will ultimately lead you to the culprit. And this is the main differences. This is what I spoke about. You can look at it right now. And we have a case where we found an executive stealing money from a bankrupt entity, or about to be bankrupt entity. He was an executive at the company. He took, it was 225 Bitcoin, and he just transferred it to himself. That's all. He transferred it to himself through a third-party wallet. And we had obtained a court order that said this asset, this wallet has to be frozen. The problem with obtaining a court order saying this wallet has to be frozen is it's not frozen like a bank account would be frozen. It's frozen because there's a court order saying, hey, please don't transfer it. And so every day we checked it, every day we checked it, every day we checked it. One day it was gone. And so we filed an emergency action in federal court, in the bankruptcy court in Delaware. We had a crypto tracing expert get qualified in federal court. And we showed the judge, look, here's where the crypto was, and here's where it is now. And this is in violation of the court order. And the judge ordered that he had to return the assets in 30 minutes to the bankruptcy trust, which is who we represented. And ultimately what happened is there was a recorded phone call, a recorded Zoom conference that was held that night, where we directed him to literally click the buttons on the screen to transfer us back to Bitcoin. And we got it back late in Friday night, about 1 in the morning. So that's crypto tracing. It's one of the key things that we do. I think there is a common misconception that stolen crypto is just stolen and gone forever. I would much rather trace stolen crypto than trace stolen fiat. And I think you have a much better chance of recovery at stolen crypto than any other asset because there are mistakes being made. They're not as smart as they think they are. And there are constantly ways to trace wallets to those key repositories of information, which are the cryptocurrency exchanges. So we're prepared to answer any questions. I wanted to leave some time here, and then we've answered some questions in the chat. So whichever ones you want us to start with, we're happy to answer.
The session was also very insightful, judging from the comments from the participants. I note that in the course of the presentation, Joseph had answered some questions. So to the participants, it would be useful to check the Q&A box just on that answer to determine if Joseph has answered your question. But I'll also say some questions here as well that came after you started answering some of the questions. Any Nigerian related questions will be dealt with tomorrow. So if you asked any Nigerian related questions today, please bring them back tomorrow so we can answer them.
I see one in the chat that I can answer really quickly that I think is an important one. There was a question is how do off-exchange transactions work? And this is how they work. If I am in New York and you are in Nigeria and you give me your digital address, I can go into applications called Uniswap or SushiSwap or other non-repository exchanges and type in your digital address and just send it. And what that means is that there's no entity that ever takes possession of that token except for me and you. And if you do it that way, you're not passing through an exchange. So it never goes through those omnibus hot wallets that we were discussing before.
Okay, thank you. So there's a question here I find very interesting from Adekola Thompson. He or she is asking that, are there any regulations on the standardization of smart contract codes?
So the answer is not yet. There are a number of third parties that claim to be auditors of smart contracts. And so there are third parties that have a system by which they will look into a smart contract of a particular token and say, does this actually do what they're claiming it does? And it's very important for people to understand that whatever the smart contract says, that's what the transaction is going to be. So forget about what they said on Twitter, forget about what they said in the offering materials or the marketing materials or on YouTube. Whatever's in the smart contract, that's what's going to happen. And in fact, we are pursuing a number of cases at the moment in federal court concerning smart contracts and how they're working, because there's very little regulation on it. And I think very few courts really understand it. But the core thing that needs to happen is whatever they market needs to be the same thing that's in the smart contract. And if it's not, we take the position that there were misrepresentations made about the nature of the investment.
Thank you. So this other question is from Omade Okoya. Says, in the event that the digital wallet is registered to an organization and registered in such a way that you cannot identify the real owners, and this is after obtaining further information using a John Doe suit, what options are left to pursue by a plaintiff?
Okay, let me just understand the question. I think is it written here? It's if you can trace it to an organization, but you can't identify the real owners, what do you do? And so we have had that situation before where we have some indications of what the organization is, but you don't know who it is, you don't know what it is. And so what you do is you can file a lawsuit, and we have filed many of these lawsuits against either a John Doe or the name of the project. And so sometimes there will not be a corporate entity, but there will be a name of a project saying this is, I don't know, Dog 123. And so you sue Dog 123, and then you file a motion for jurisdictional discovery. And what that means is you say, hey, judge, I know what it is. I know where their assets are. I just don't know their name, right? And so that's the information that I need. And what you often need to do is you need to identify or try to identify third parties that would have identifying information about your target. So for example, if they have accounting firms or law firms or marketing firms or one of these smart contract auditors, you want to find third parties they've done business with that may not have that same issue, meaning they may have a corporate entity and that payment to them came from somewhere. And so what you really want to look at is who else they're doing business with and how to identify them. We've identified targets in the craziest ways. I mean, somebody picks up the phone and makes a phone call when they shouldn't have from their personal cell phone. We find them at social media, on Facebook. We find them commenting about something, saying they were at a certain event. I mean, there are a variety of ways you would identify someone. But yes, that's the way we would start that kind of suit. And there's often a major investigation phase before we go to file, where we do everything we can to identify who this person is. And oftentimes it's by identifying who they've done business with in the past.
Thank you. In the interest of time, again, I will only take 2 more questions. And someone is asking for the tax treatment of cryptocurrencies in the US.
Yeah, so I'm not a tax lawyer, so take it how you will. But the IRS has been increasingly focused on the taxation of cryptocurrency. I think there was a reference in the chat to the personal tax returns. There's now a disclosure requirement saying, do I or do I not, have I or have I not engaged in any virtual currency transactions in the past year? So they are increasing their focus, they're increasing their team on identifying these transactions. The impact of that check the box on your personal income taxes is if you check the box no and you're wrong, are you not being truthful, the IRS can say that you've committed tax fraud or that you otherwise committed tax avoidance. The other thing that everyone should be aware of is the IRS have served their own John Doe notices on most cryptocurrency exchanges in the US. And they've sent a subpoena saying, I want every single person's identity that transacted more than 20K US, 20,000 US dollars in the last year, everybody. And most exchanges have just complied. There have been a few that have fought the issue and they said that this is unfair, 20,000 is too low, this is a violation of my terms and conditions with my customers. And only one court has ruled that it was overbroad. Every single other court has enforced them. We expect that to continue to increase in enforcement and in regulation. There has been a number of statements from the task force in the US on the tax side saying that they believe that there's a significant amount of tax revenues that have not yet been recovered due to just a failure to disclose. And remember, you're not trading these assets in an account like a bank account usually. And you can be trading off exchange transactions like we talked about. You can be trading a series of different cryptocurrency exchanges. So it's very rare where you just trade all of your assets in one place and say, okay, send me my 1099 form. It can be very complicated to identify what your tax liability is, even if you want to do it correctly. And there are also not very many tax professionals that are well-versed in this area yet. Everyone's still catching up. And so I do think it's an area of enforcement. It definitely has increased focus, and they're looking back in time, 2017, 2018, 2019. And so we expect more enforcement here on the tax front.
Thank you. So I'll be taking the last question now, and I'm honestly conflicted as to the questions asked, because we have many great questions here. But so someone is asking if the US has had any success with crypto tracing on decentralized exchanges. If you speak to that a little bit.
So success. We have the question always on decentralization is it truly decentralized? And so we've had investigations that went through decentralized exchanges and we've asked for information. Sometimes we get it, sometimes we don't. There hasn't been a US case where they've required a quote unquote decentralized organization to produce information. Some of that is because much of this is done informally through letter writing and sometimes just personal connections. The issue of decentralization is still being tested in all of US courts and in many of our matters. The reason is because it is so very important for the company or the exchange to argue that they are quote unquote decentralized. And decentralized, just so everyone knows, that means that there are not a group of people making decisions. There's no executives, there's no board, there's no corporate entity. It's all community run. It's all run by votes. It's all run by the people that own that particular token. It is very, very difficult to actually prove that an entity is decentralized. And it does appear to us, at least in many of our cases, that certain claims of decentralization are not really true. And when you unpack these claims of decentralization, the question is, are you actually finding out that it's just 4 or 5 people in a room making a decision? and that's how the company is run. Because if that's the case, that's not decentralized. And so to answer your question, there have been no US cases yet. I do expect US cases on this issue. And I think an open issue to decide in many of the cases that we're litigating right now is when a company or an exchange or an issuer or whoever claims they're decentralized, what does that really mean? And when are the courts going to rule that, no, that's not true decentralization?
Okay, Joe, thanks very much for that. On that note, we may have to call it a day. I know that there's still a ton of questions that keep coming in. As I mentioned, we will try to log these, share this with the team, find a way to share the feedback with the rest of the participants. As you know, today is just day one of 3 days. Tomorrow we'll be going into a session that brings all of this home, as we'll be looking very closely at the fintech landscape in Nigeria. We'll be looking at tomorrow we have a power pack three sessions. One that looks at an overview of the fintech landscape in Nigeria, another that looks at the regulatory layer of the land, and of course one that talks on AML and CFT regulations. That promises to be interesting because I remember when the MWE team was speaking, we do have similarities around AML expectations and requirements in the US and in Nigeria. I want to take a moment to thank everyone on the MWE team, Joe, Aaron, Alexandra, Daly, Dan, everyone, Ethan. Thank you all so much for being a part of this. In the event that you have some time tomorrow, please join us tomorrow for the sessions. Of course, every one of our participants, almost 995 of you, thank you so much for joining us today. Thank you so much. Thank you so much. We look forward to incredible sessions tomorrow. Again, we start at 3 p.m. tomorrow. We will start on time, but tomorrow we'll be running up until about 6 p.m. If we do have some time tomorrow, we will try to take some of the questions that were left over from today. We will try to see if we can squeeze those in tomorrow. But I just want to say thank you very much on behalf of the chairman of the Nba-Icle. Unfortunately, he's not here with us. And everyone else, we want to say thank you for everyone. Thank you to everyone. We look forward to speaking and meeting with you tomorrow. Thank you all and have a good evening. Bye-bye, everyone.
Thanks for having us. Appreciate it.
Thank you.
Thanks, Joe. Thanks, Aaron. Thanks, Alex. Thanks, Daly. Thanks, Dan. Thanks, everybody. Bye. Thanks, Ita.